Any mention? Okay. Any mention?
May I please, Your Lordship? Lordship, I beg to mention item number 9, Lordship. I have already informed the other side also, Lordship. Lordship, we would like to withdraw this matter, Lordship.
Then let the matter be caught up.
Yes.
Please, Your Lordship. Lordship, I beg to make a mention of item number 5, Your Lordship. Lordship, the learned TSGI is not keeping well, Your Lordship. I pray this matter may be listed after 2 weeks, Your Lordship.
5?
This is a fixed item, in fact.
Yes.
The last order says that no more adjournment on any ground.
You're appearing for?
I'm for petitioner, Your Lordship.
Who's what is this?
The petitioners
Date of
have already
the-
argued. It's my turn to reply.
Then you can reply. You are
Yes.
there. You take notes. If you want to respond, we'll see. Otherwise, you have already said your piece. And who's the? There are two matters here. You're appearing for?
One is already heard. Number 2 has already been heard, my lord. Both sides have been heard.
Yeah.
So let me reply, my lord. They'll hear.
Yes, but you be there. We'll see.
Similar prayer for item number 6, Your Lordship.
Again,
Humbly pray for a week's time, Your Lordship. The learned TSGI is not keeping well, Your
CBI
Lordship.
case discharge. Time and again they're praying for time. Last time they have assured the court that they will argue the matter. I don't know.
this was against discharge.
Yeah, discharges. Because I'm the sufferer, I'm not getting my benefits. That's what, and they are taking time.
Week's time, Your Lordship. Last chance may be given, Your Lordship.
Last chance, so many last chances given. Right
The
from
learned TSGI is not keeping well, Your Lordship.
Accommodation has been sought for on behalf of the Leonard DSGI appearing for the petitioner on the ground that he is not keeping well and could not appear before the court today. Mr. M.F. Qureshi, Leonard Counsel for the respondent. Only one respondent?
no, number 3. I'm ready for number 3.
Respondent number 3 has submitted that this matter, besides being a long pending one, many opportunity was given to the parties to be heard in the matter. However, the hearing could not be concluded till date. Though no strong objection is raised to the preamble, it is prayed that no more opportunity may be allowed. This court, after due consideration of this submission made, would allow the preamble, since the same was made on grounds of personal difficulty. However, it is made clear that no further adjournment will be allowed on the next date. Any of the parties or counsel who could not appear should make adequate arrangement for the matter to be heard by any other counsel. Place this matter after 1 week.
Highly obliged, Your Lordship. May I please, Your Lordship, I beg to mention item number 11, Lordship. Due to personal difficulties, after 1 week, Lordship.
On premier with the appellant, this is matter up to 3 weeks.
Highly obliged, Lordship.
May it please Your Lordship. Your Lordship, I beg to make a mention of item number 8, Your Lordship. Your Lordship, I pray if this matter may come up after 2 weeks, Your Lordship.
You are for?
For respondent, Your Lordship.
That promotion matter?
My lord, my lord. The DPC is still awaited, my lord.
DPC?
That proceeding of the two DPCs, my lord, has called for. That is yet to.
Oh, they are to.
Yes, my lord.
This is with regard to this ACP? I mean, sorry,
no,
ACR?
no,
Not
my
ACR.
lord. It's with regards to the promotion, my lord. Based on which the DPC, they have constituted two departmental promotion committee.
Yes, yes.
My lord, that's still awaiting.
On payment by the respondent Union of India, not objected to by the petitioner, matter is adjourned. List the same after 2 weeks.
Similar prayer for item number 10 as well, Your Lordship.
Then,
Yes, Your Lordship. Consent has already been sought, Your Lordship.
nobody is here.
I've
You have the
informed
petitioner?
them, Your Lordship. Mr. Panthi, I've informed him, Your Lordship.
On payment by the respondent, matter is adjourned. List the same after 2 weeks.
Your Lordship, I beg to make a mention of item number 12 to 15 as well, Your Lordship. It's a joint prayer, Your Lordship.
It's for the respondent, item number 12, Your Lordship.
13, 14, and 15, Your Lordship.
Is that cancellation of bill?
Yes, Your Lordship.
Yes.
On payment by the petitioner, Union of India, not objected to by respondents. Matter is adjourned. List the same after 2 weeks.
Obliged.
Much obliged.
Good evening.
From the main list, item number 1.
Your Lordship, in this matter, we are yet to receive instruction from the client. I pray for 2 weeks' time, Your Lordship.
But you should be definite about your stand. Whether you are willing to pursue the matter or not.
Your Lordship.
It's 2021 matter. Miss the counsel for the petitioner has submitted that the instruction sought for from the petitioner has not yet been from the petitioner's court has not yet been obtained, and therefore the counsel could not proceed in this matter. It is therefore prayed that some more time may be allowed for such instructions to be received. This court, while allowing the prayer made, would observe that this matter is that of the year 2021, and it is still the admission stage. It is therefore the duty of the petitioners to make up their mind as to whether to pursue the matter or not. Accordingly, this matter is now posted after 2 weeks.
Your Lordship, I appear for respondent number 12 here.
Doesn't matter. Are you objecting to the prayer made?
No, I'm not objecting. Just like my appearance may be recorded, so that's why I made that mention here, Lordship.
So you list his appearance as number 1. Makes no difference, Mr. It will be there. Item number 2.
Lordship, I appear for respondent number 9 here.
or that
The parties are yet to file their reply, Your Lordship, in this matter.
Your Lordship, I had made a submission on the last occasion that I'll be filing my reply as well my affidavit in opposition during the course of the day.
yes, so
But the concerned officer met with an accident that day, so I'll be filing today during the course of the day by serving an advance copy to the other respondents as well as the
you are
petitioner.
NVCC.
Yes, yes, Your Lordship.
The other respondents have filed their.
Your Lordship, I need some time. I need some time, Your Lordship.
So that means no counter affidavit have been filed in this case.
Lordship,
No, not
Your Lordship, from the states, and we haven't filed. Lordship, it requires 2 weeks time.
We have as many as 9 respondents.
I am for the responder 1 and 2.
Okay, 8 is not filing. State is 3 through 7, and union is 1 and 2.
1 and 2.
The learned counsel for the respondents who are yet to file their the respondents who are yet to file their counter affidavit have not done so, and as prayed for by the respective counsels for the said respondents, the counter affidavit is allowed to be filed within the next date fix. This is matter after 2 weeks.
If you oblige, Your Lordship.
Item number 3.
Please, no. I'm appearing in this matter.
Yes, Mr. Khatri, what is the?
Yes. The main matter is still pending, no? The other matter,
that is
the
matter before the.
My lord, the matter
before
before,
the DP.
in the
Yes,
before
yes.
the division bench, my lord, the state is directed to file a report on that, my lord, and the matter was supposed to come on 26th of March. Since it was a holiday, my lord, we couldn't file. So probably, my lord, will be filing a report with regard to the last meeting that was held. So, my lord, this matter may come after 2 or 3 weeks, my lord. Therefore, after the division bench matter is called, my lord. So we can have this matter after that.
Kindly.
Learned counsel for the petitioner, Mr. R. Khatri, as well as Ms. R. Kulni, learned G, appearing for the state respondent, have submitted that the matter similar and almost identical matter pending before a division bench of this court has not yet been disposed of.
No, not yet.
It is therefore prayed that in the meantime this matter may be adjourned for the time being. As prayed for, matters adjourned. List the same after 4 weeks.
Highly obliged, Lordship.
Excuse me.
Item number 4.
Kindly.
You have filed?
Yes, Lordship.
Are you filing a rejoinder?
No, Lordship.
Mr. S.A. Sheikh, learned counsel for the state respondent, has submitted that the counter affidavit on behalf of such respondent has been filed. Mr. Nkira, learned counsel for the petitioner, has submitted that no rejoinder is required to be filed. Will be filed in this case. No rejoinder to the said counter affidavit will be filed by the petitioner. On prayer made by the parties, the matter is now posted for hearing. This is the same after 2 weeks.
Obliged, Lordship.
Item number 5.
May it please your lordship, your lordship, I humbly request if this matter may be taken up after a week, your lordship, as the counsel for the petitioner, conducting counsel for the petitioner is not keeping well, Your Lordship. Although we have completed our submissions, Your Lordship, but then...
So let me complete my submissions. If they want to reply, let them reply later.
Which will happen again on the next date, Your Lordship. So it will be better, Your Lordship, if...
He's already made a mention in the morning. And the court has...
So, see, what we have proposed to do
Yes, Lordship.
is for the respondent to make a submission. You can note down the submission, and if required, you can respond on the next date. That would solve, you see, a lot of problem in the sense that we will not be wasting time on this matter, you know, over and over again. You can note down this. You are there. You are competent enough to.
Wait, please, Your Lordship. Your Lordship, on the last occasion, I had drawn this court's attention to section 47 and section 60 of the CPC.
Just one. This is CRP 28.
This is CRP number 21.
21.
It's already been heard.
I took 21.
21.
Please.
My Lord, on the last occasion, I had drawn Lordship's attention to section 47 and 60 of the CPC. My Lord, 47 reads,
yes.
All questions arising between the parties to the suit in which the decree was passed or their representatives and relating to the execution, discharge or satisfaction of the decree shall be determined by the court executing the decree and not by a separate suit. Where a question arises as to whether any person is or not the representative of a party, such question shall, for the purpose of this section, be determined by the court. So 47 says that any dispute in respect of the execution of decree has to be raised before the executing court. And it cannot be by way of an application under Article 227 as has been done in the instant case. Now, my Lord, representative here is important, the word representative, because the petitioner here is the State Sports Council, represented by the Secretary, who also happens to be the Director of Sports. He holds dual charges. As a Director of Sports, he has filed CRP number 28, and as a Secretary of State Sports Council, he has filed revision petition, excuse me, the instant revision petition. Now we'll come to 60. Section 60.
Yes.
The following property is liable to attachment and sale and execution of a decree, namely lands, houses or other buildings, goods, money, banknotes, checks, bills of exchange, hundis, promissory notes, government securities, bonds, or other securities for money, debts, shares in a corporation, and save as hereinafter mentioned, all other saleable property, movable or immovable, belonging to the judgment debtor, or over which the profits of which he has a disposing power, which he may exercise for his own benefit, whether the same be held in the name of the judgment debtor or by another person in trust for him on his behalf. Now what has happened here, my lord? A decree has been passed. My lord, will come to the list of dates. List of dates is very important. I have to copy of the list of dates. Page of the file. Page of the file.
This updates in yes.
Yes. Now, let briefly, the list of, as per the list of dates, now the money suit was filed in the year 2009.
Yes.
By the respondent here against the state for the recovery of 8 crores 88 lakhs so and so. Now, on 19/8/2011, judgment passed whereby the suit was decreed in favor of the plaintiff. Well, then on 19/12/2014, judgment passed in FAO number 10T of 2013 by the ADC upholding the trial court's order because the government had filed an appeal.
Yes, miss, do you have this copy?
No,
You don't have your file with you?
We'll give an
I
extra
don't
copy.
have, Your Lordship, but I don't have the list of dates, Your Lordship.
We have already supplied the last occasion, but we can give them.
Do you have?
I am in CRP 28.
What is, these are common facts.
Maybe they can share.
Whenever a matter is taken up, you should be aware of what is going on. You should be you should keep abreast of the proceedings. Yes, please continue.
Well, in 2014, money execution case. Now we had filed this money execution case number 13T of 2014 for execution of the decree dated 19/8/2011 passed by the trial court. Now, against the appellate court's order, the respondent had also filed a review petition. Now, on 15/6/2015, judgment and order passed by the Additional Deputy Commissioner in review petition number 1T of 2015, filed by the state against the judgment and order dated so-and-so, passed in FAO number 10 of 2013. Now, on 3/12/2015, order passed by the trial executing court in money execution case number 13T of 2014, directing the state, the judgment debtor to deposit 50% of the decretal amount by way of a bank guarantee. Now, on 4/3/2016, my lord, the trial court directs the Meghalaya Rural Bank to transfer the amount of 5 crores 27 lakhs 90,248 to the account of the respondent, which was done. Now, on 7/3/2016, the bailiff directed by the executing court to provide the bank statement of the judgment debtor fixing 4/4/2016 for report. Now, this is important. 4/4/2016, report of the bailiff along with the bank statement and letter of the Director of Sports of even date. As per the bank statement, an amount of 15 crores was received by the Sports Department on 4/4/2016. On the same day, an amount of rupees 14 crores 1,06,710 was transferred to HDFC Bank Rinjab branch. Now, this is important, my lord. On the same day, when they were supposed to file a report before the court, an amount of 15 crores was deposited in the bank, in the account of the director. Now, before submitting the report to the court, what the director did, he transferred this amount of 14 crores to the account of the State Sports Council and then filed a report saying we don't have enough money. That is what exactly happened. My lord will see, I have also annexed the copy of the bailiff report and the letter of the Director of Sports and the bank statement. At page 5.
Page 5?
Page 5 of this list of dates, my lord.
Yes.
on 4/3, the CR was put up today. Received confirmation letter dated so-and-so from the Meghalaya Rural Bank, confirming that the bank guarantee number so-and-so for an amount of so-and-so has been transferred to the account of the decree holder, Srimati so-and-so. Fixed on 7/3/2016 for report of the bailiff. Now on 7/3, CR put up today, the Nazir bailiff is present along with the report, seen and perused the same. Considering that 50% of the decretal amount has already been transferred into the account of the decree holder, Nazir bailiff is directed to provide the statement of the account of bank account of the judgment debtor on the next date for further necessary orders, fixed on 4/4/2016 for report of the bailiff. Send a copy of this order to the bailiff. Now on 4/4/2016, CR put up today, bailiff is present and has submitted his report dated 4/4/2016. Seen also the statement of accounts provided by the Meghalaya Rural Bank. Decree holder is absent, fixed on 6/4/2016 for appearance and for the orders. Now, my lord, will come to the next page, page 6, which is important. Yes. The order dated 8/4/2016. CR put up today, bailiff is present and has submitted his report dated 8/4/2016. The branch manager of HDFC Bank is present in person. Seen also the report dated 7/4/2016, duly sent by the branch manager, Dranjah branch, HDFC Bank, seeking further details with regard to the decree pass and to instruct the bank accordingly, as the name of the account holder of account number so-and-so does not appear in the instant money execution. Peruse the report of the bailiff dated 4/4/2016 and 8/4/2016. After perusal of the reports, this court is of the opinion that white order dated 7/3/2016, this court had directed the bailiff to provide the statement of the bank account of the judgment debtor and fixed on 4/4/2016 for bailiff's report. However, as per the report of the bailiff dated 4/4/2016, it is seen that an amount of rupees 14 so-and-so was withdrawn from the account of the judgment debtor and transferred to the account of the Secretary State Sports Council, having account number so-and-so on 4/4/2000 itself. This transfer was done after the receipt of the order dated 7/3/2016 passed by this court. However, the learned counsel for the decree holder and learned counsel for JD is absent. Fix on so-and-so for appearance of the parties and orders. So subsequently, what the lower court did, on realizing that the judgment debtor is trying to avoid the decree pass, has directed the HDFC Rinja branch to freeze that account of 4 crores. My lord, the petitioner here before your lordship has tried to portray a case that they are strangers to the suit, that he is a stranger to the suit and he has no knowledge regarding the money suit, the title execution, or the decree. That is their case, basically. Now, in respect of maintainability, I have submitted that even a stranger to the suit, judgments are there. Even a stranger to the suit, if at all he is dissatisfied or aggrieved with the order passed by the executing court, they have to approach the executing court and not by way of 227. My lord, they have approached this court after 4 months of the passing of the order and said they were aggrieved. Now, lordship, another very intriguing case in this matter is we have sought for RTI from the State Sports Council and also the Director of Sports. Now, as per the RTI, which is on record, my lord, I filed additional affidavit and I filed the rejoinder also. The budget of the State Sports Council is somewhere around 7 crores on that particular year, 2016, 2017. Now the question is, how? Where was the question of transferring 14 crores, that too on a single day? The petitioner was very much aware of the going on within the court. Now, taking advantage of the fact that he holds dual position, he transfers this and said, I'm a stranger to the suit. Now, can this be allowed? can this be permitted? And in their petition, Lord, they have also annexed a statement of the accounts of the State Sports Council. Now, as per the RTI, which we have received, for the year 2016-17, that account does not figure anywhere. They have not filed any rejoinder to our affidavits to refute the fact that the account statement which they have annexed, I'll just annex at page, we will just come to page 151 of the revision petition. No, not 151. No, page 145. This is annexure 16.
Page 145.
145, annexure 16, Malon.
Annexure 16.
Annexure 16.
It's not here. Okay. One 145.
145. Today. Yeah, I think it's that.
Okay.
CRP 21.
Yes.
My lord will see, as per section annexure 16.
Yes.
This the heading is MS Secretary State Sports Council of Meghalaya, JN Stadium, Polo, Shillong, 79, so. The Lordship will see that this particular account has been used, as per their own admission also, has been used both by the State Sports Council and also by the Director of Sports for other activities. My lord will come to page, very interesting, page 148. All these transactions has been done in favor of the Director of Sports for making payment to the various associations in the state. I will come to my affidavit, my lord, to show that they have not disputed that this particular account is being used not only by the State Sports Council but also by the Director of Sports. It will come to page 151.
It is not a joint account.
It is not a joint account, madam, but it is being used by the Director of Sports. I don't know how, madam. Very irregular. Very irregular. I don't know how. But it appears that payments on behalf of the Director of Sports is being made from this account. Now, my lord will come. Yes.
In a statement or in an
Yes.
account,
it should be.
You will notice there are certain factors
Yes.
which will determine the account.
Yes.
That is the account holder and the either payment made or received.
Yes.
You can make payment to any party. You can receive payment
True.
from any party.
Yes.
So it is, you see, the principal factor here is the account holder. Now the account holder here is the secretary,
State Sports Council.
Now you're saying that the director sports council is also, disbursing
Making
making
amounts
payment
from
and
this
also,
account.
and also receiving money, from that cannot be.
No, my lord, I'll come to the RTI where they've stated yes, we are doing it. My lord, will come to first before going to there, page 151, my lord.
No, that would not. You see, that would not conform to the
It does not.
accounting process.
What I'm trying to portray, my lord, what I'm trying to say is that whatever has been done by the petitioner here has been done by an oblique motive. My lord, on as page 151, my lord will come to page 151. On 7/6/16,
Miss, you note down these.
Yes.
These points. These are the points you should.
and
clarify.
they have not filed any rejoinder to all this, my lord. Page 151
Yes.
on 7/6/16, my lord, that's somewhere in the middle.
Yes, there are
An amount of 4 crores.
There's a number of entries
Yes,
here.
yes. No, what I want to show, my lord, an amount of 4 crores was sent to the Director of Sports and Youth Affairs.
7/6.
Yes. Now, my lord, why I'm showing you all this, my lord? On seeing all this, the petitioner sought for an RTI to a certain how? How is it possible that the State Sports Council,
Yes.
which is solely dependent on the Director of Sports for their budget, annual budget, for the finances,
Yeah.
would transfer 4 crores to the Director of Sports instead? My lord, in the affidavit in opposition filed by the respondent, this will be quite clear, my lord. We have filed an affidavit in opposition. On behalf of the respondent number 1, my lord. No, 21.
Affidavit dated.
Yes, affidavit we filed on 27/6/23. I Shri Kimfa S. Marbanya. Affidavit in opposition on behalf of respondent number 1.
Yes.
21.
Yes.
What I want to impress, my lord, although they have on affidavit, they have stated that this account belongs to the State Sports Council, my lord.
Yes.
The RTI we had sought for this particular account does not figure anywhere. It does not figure anywhere, my lord. We have taken pains, my lord, to find out.
It doesn't figure anywhere in what sense?
In the my lord, we have done a compilation. This is all we
You
have
mean
received.
in the books of account?
Yes. In the books of account, my lord, I will just, this is regarding the year 2016-17. This has been supplied by the State Sports Council. Now, Your Lordship will see there is as many as 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15 accounts maintained by the State Sports Council for the financial year 2016-2017. Now, this particular account, Annexure 16 to the writ petition, does not figure anywhere. I'm not making this up. This is from what they have supplied to us. So it's really a wonder how the accounts are maintained by the State Sports Council.
See, here it says Annexure 16.
Yes.
This account branch is Renja.
Yes.
Address is HDFC Bank.
Yes.
Account number so and so.
Account number 501000133667050.
See, Mr. Dingdo.
Yes.
Here, I think there's an indication that this is joint holders. It says. See on the left side.
Secretary, State Sports Council of Meghalaya. Yes. It indicates joint holders, but it's blank. Yes. But the account number is important, my lord. The account number, this...
If it is a joint holder, then
Yes.
it would not appear here.
Yes.
Because this is exclusively, account maintained by the State Sports Council.
That's what they claim, yes. my lord.
Let's
Assume,
that it is.
yes.
So if this is indeed a joint account, it'll have to figure in somewhere else. It is for the bank to clarify on this.
Yes. But the surprising factor is, why has this particular account not been reflected in the book of accounts, in the financial statement for 2016-17? Because that's a different issue. But what I'm trying to say, my lord, is that all this was made up for the purpose of only to avoid paying the money to the decree holder. That is what is important, my lord. They have created a lot of, I don't know, financial irregularities here.
You made a point, but that is, like you said, that is not the issue here.
Yes. But what I want to stress is the fact that the action of the petitioner, how he has maneuvered, how he's been able and come before this court and say that I'm a stranger, State Sports Council has suffered because of the action of the trial court in executing the decree. So this is an important factor, my lord, has to keep in mind. Because according to me, the petitioner here is not a stranger to the suit in the absolute sense, because he was aware of the proceedings. A stranger to a suit would be a person who is not at all aware. He did not know regarding the suit. He did not know regarding the execution of the decree. Here the petitioner knows everything. In his petition, he has narrated the entire facts as placed in my list of dates, from A to Z. It is not that he is not aware. Now, my lord, will come to my affidavit in opposition.
So that would prove his complicity.
Yes. His complicity, yes, in the judgment. I'll come to the judgment, my lord. My lord, will come to the affidavit in opposition. I will just, it's not very long. My lord, will come to page 7, para 17. But as regards the averments made in para 4 of the petition, the answering respondents say that in order to have a clearer picture of the financial aspects and accounts maintained by the petitioner and the Director of Sports, respondent number 3, he had sought for information under Right to Information Act 2005 from both the entities. The Director of Sports, through its PIO by letter dated so-and-so, has answered 5 queries raised by the answering respondent, and is indeed revealing to note that apart from other anomalies relating to the budget of the petitioner, payments are being made by the respondent number 3, Director of Sports, through the account of the petitioner, which implies that there is no difference if money is received or paid from either of the entities. To buttress this fact, the answering respondent craves leave of this court to cite examples of the irregularities, if not illegalities, being perpetrated by the State Sports Council and the Director of Sports as follows. The annual budget of the State Sports Council, routed through the Director of Sports for the year 2016-17, non-plan is 39 lakhs, plan is 750 lakhs, which makes it a total of 7 crores 89 lakhs 50,000. This was the budget of State Sports Council for that particular year, 2016-17, 8 crores. So where was the question of transferring 14 crores? Next question is, how did the Director of Sports and Youth Affairs, Meghalaya, transfer 15 crores on 4/6/2016 to the SCC? In answer to the query number 2, whether any payments has been made by the Director of Sports through the accounts of the State Sports Council in the year 2014-18, the answer is yes. It's an emphatic yes, as per the details provided in Annexure 3. So they've said yes, we make payments from the accounts of the State Sports Council. Director of Sports makes payment also. So you cannot turn around and say, I'm a stranger to the suit, this account is strictly for State Sports Council. That is not the case. D. As per the details provided by the PIO, Sports and Youth Affairs at Annexure 2, for the year 2014-15, a total amount of rupees 12 crores 77 lakhs was transferred to the State Sports Council, whereas as per the annual budget for the year 2014-15 for the State Sports Council has been earmarked at 8 crores 27 lakhs 90,000. Here also, how all this is happening, my lord? Of course, that is a different issue. Let will just come to page 17 of this affidavit, my lord. Page 17. Page 17, my lord, is the letter from the Director of Sports to the bailiff Nazir, Court of the Assistant to Deputy Commissioner, East Khasiels, District, Shillong.
Yes.
Subject statement of account matter related with money execution number 13T of 2014, so-and-so versus so-and-so. Sir, with reference to the subject cited above and inviting a reference to the judgment order dated 7/3/2016, he is very well aware of the order passed on 7/3/2016 in the case number.
Naturally, he's issuing this letter as a Director of Sports.
Director of Sports. In the case number noted under reference, I am to furnish herewith the statement of account of the Director of Sports and Youth Affairs, Meghalaya, Shillong, having an account at Meghalaya Rural Bank, MTC, Police Bazaar, Shillong, for favor of your information and necessary action. And this is the enclosure, the next page, Annexure 5, page 18.
Yes.
Which shows that on 4/4/2016, before he files this report to the bailiff, that 14 crores has already been transferred to State Sports Council. My lord, will come to page 22.
Yes.
This is the reply from the Director of Sports and Youth Affairs, Shillong. Whether the annual budget of the State Sports Council is routed through the Director of Sports and Youth Affairs every year. If yes, please provide the details from the year 2014 to 2018. And they have supplied the details and said yes. All funds for the State Sports Council is routed through the Director of Sports. Whether any payment has been made by the Director of Sports and Youth Affairs through the accounts of State Sports Council in the year 2014 to 2018. If yes, please provide the details. Yes. Details at Annexure 2. Now, whether the funds for the State Sports Council by the government are routed through the Office of the Director of Sports, if yes, the same detail. No? Now, number 4. whether the Director of Sports and Youth Affairs has received any funds, money transfer from the account of the State Sports Council in the year 2014-18. If yes, kindly provide the details of for the purpose thereof. And in fact, emphatic does not arise. But my Lord has seen that on 7/4, an amount of 4 crores was sent from the State Sports Council to the Director of Sports.
Yes.
My Lord, page 23 is the annual budget of the State Sports Council, which is nowhere close to 14 crores in any of the years. My Lord. We are concerned with 2016-17, that, as I have shown, is less than 8 crores. My Lord, will come to page 27. These are the various payments made through the account maintained by State Sports Council now.
Yes.
These are funds received by different state sports associations from 2014-15 to 2017-18. Now, all these associations have been receiving grants from the Director of Sports, but payment has been made through the accounts of the State Sports Council. This is their own admission, and they have not filed any rejoinder to rebut all this, and they cannot rebut also, my Lord, because basically this is RTI information which I have received. My Lord, I'll take your Lordship only another aspect. In my additional affidavit, my Lord, because some more information was given to us. Additional affidavit filed on 9/8/2023, my Lord.
Yes.
Your Lordship will come to page 9. These are grant in aids.
Yes.
As per the ledger account maintained by the State Sports Council. Here also, my Lord, will find that the account statement annexed by the petitioner to this revision petition does not figure.
Yes.
Why it does not figure, my Lord? For the obvious reason, because if it figured, everything would have come out in the open. That account had been maintained rather open just for the purpose to avoid the execution of the decree.
No, but you'll notice in that joint account, if it is a joint account.
If it is a joint account.
There are a number of entries there.
Number of entries. I'm not saying there are not no entries, there are a number of entries. But most of the entries are in respect of payments made on behalf of the Director of Sports. That's on behalf of the Director of Sports. Now, if they say that, no, the Secretary of State Sports Council is a different entity altogether, as we understand, as I would, and your Lordship also has said so, that the account for State Sports Council should be exclusively for the State Sports Council. But here what I have shown is that the account of the State Sports Council and the Director of Sports are interlinked. They've been making payments. Now the Director of Sports says, I have never received 4 crores. Whereas as per the RTI, he said he has never received any money from the State Sports Council. Whereas the evidence show otherwise. Who are they trying to hide? My lord, I think the judgments I've already gone through. On the last occasion. But as I said initially, my lord,
You've made a,
even
have
if
you made a compilation?
yes. Okay. With an index also.
Yeah. Yes.
My lord, in the judgment in Rahul Shah case, my lord, 2021, the recent judgment, volume 6, SCC 418. Here, my lord, the Supreme Court has highlighted the abuse of the provisions, execution of a decree. The Supreme Court has gone to the extent in saying that in India, getting a decree is half the battle won. Your real battle starts when the execution comes into play, which your lordship is also very well aware.
Naturally, you see, naturally. Yeah. Execution would be resisted to any extent.
Any extent. So, my lord, in this case, the Supreme Court has laid down the guidelines. My lord, we'll just come to paragraph at, 42. I will not read the entire judgment. This is 42. 42 is where the all courts dealing with suits and execution proceedings shall mandatorily follow the below mentioned directions. 42.1. In suits relating to a delivery of possession, the court must examine the parties to the suit under Order 10 in relation. We are not concerned with that. In 42.6, my lord. In a money suit, the court must invariably resort to Order 21, Rule 11, ensuring immediate execution of decree for payment of money on oral application. Even on oral application. When it comes to money execution, the court should do it promptly. 42.7. In a suit for payment of money before settlement of issues, the defendants may be required to disclose his assets on oath to the extent that he is being made liable in a suit. The court may further, at any stage, in appropriate cases during the pendency of the suit, using powers under Section 151 CPC, demand security to ensure satisfaction of any decree. 42.8. The court exercising jurisdiction under Section 47 or under Order 21 CPC must not issue notice on an application of third party claiming rights in a mechanical manner. Further, the court should refrain from entertaining any such applications that has already been considered by the court while adjudicating the suit, or which raises any such issue which otherwise could have been raised and determined during adjudication of the suit if due diligence was exercised by the applicant. The court should allow taking of evidence. That's not important. No? 42.11. This is important. No? Under Section 60 CPC, the term "in the name of the judgment debtor or by any person in trust for him or in his behalf" should be read liberally to incorporate any person from whom he may have the ability to derive the share profit of the property. This is exactly the case. This person was in that position. So my contention is that under 227, this petition will not lie. If at all, they have an alternative remedy, and that is to approach the executing court and establish your bona fides. I've drawn your lordship's attention to all this just to show. But all this actually should be examined by the trial court, if at all they have any case, and not by way of a separate suit. The next judgment, my lord, is deception. It's in respect of Lordship.
Yes, please.
1991 SEC 513. This is Chinammal and others versus P. Arum Mugan and another.
1990.
Volume 1 SEC 513.
Yes.
Now, in this judgment, my lord, the Supreme Court has said who is a stranger and who is not a stranger. My lord, will from paragraph 10 onwards. Although this relates to immovable property, but the same principles will follow, even because property, as defined under 60, also means money. There is thus a distinction maintained between the decree holder who purchases the property in execution of his own decree, which is afterwards modified or reversed, and an auction purchaser who is not party to the decree. Where the purchaser is a decree holder, he is bound to restore the property to the judgment debtor by way of restitution, but not a stranger auction purchaser. The latter remains unaffected and does not lose title to the property by the subsequent reversal or modification of the decree. The courts have held that he could retain the property since he is a bona fide purchaser. This is the case of a bona fide purchaser. This principle is also based on the premise that he is not bound to inquire into the correctness of the judgment or decree sought to be executed. He is thus distinguished from a co-nominee party to the litigation. There cannot be any dispute on this proposition, and it is indeed based on a fair and proper classification. The innocent purchaser, whether in voluntary transfer or judicial side, by or in execution of a decree or order, would not be penalized. The property bona fide purchaser purchased ignorant of the litigation should be protected. The judicial sales in particular would not be robbed of all their sanctity. It is a sound rule based on legal and equitable considerations. But it is difficult to appreciate why such protection should be extended to a purchaser who knows about the pending litigation relating to the decree. If a person ventures to purchase the property being fully aware of the controversy between the decree holder and the judgment debtor, it is difficult to regard him as a bona fide purchaser. The true question in each case, therefore, is whether the stranger auction purchaser had knowledge of the pending litigation before the decree under execution. If the evidence indicates that he has no such knowledge, he would be entitled to retain the property purchased, being a bona fide purchaser, and his title to the property remains unaffected by subsequent reversal of the decree. The court by all means should protect his purchase, but if it is shown by evidence that he was aware of the pending appeal against the decree when he purchased the property, it would be inappropriate to term him as a bona fide purchaser. In such a case, the court also cannot assume that he was a bona fide or innocent purchaser for giving him protection against restitution. No assumption could be made contrary to the facts and circumstances of the case, and any such assumption would be wrong and uncalled for. 14, my lord. This proposition we are, however, unable to accept. In opinion, the person who purchases the property in court auction with the knowledge of the pending appeal against the decree cannot resist restitution. His knowledge about the pending litigation would make all the difference in the case. He may be a stranger to the suit, but he must be held to have taken a calculated risk in purchasing the property. Indeed, he is evidently a speculative purchaser, and in that respect, he is no better position than the decree holder purchaser. The need to protect him against restitution, therefore, seems to be unjustified. Similarly, because, my lord, the prayer here is to return back that money also. Restitution. Yet the Supreme Court is a person who, even if he is a stranger to a suit, but is aware of the proceedings, he cannot take advantage and come to court and say that I am completely unaware of everything. Now, I will not burden my lord with too many judgments. My lord is well aware of Shalini Sham Shetty and another case that is there. But the latest on this is Nilai. Virud Nagar Hindu Dharma Sabai and others. This is 2000. We have given.
Yes, this is 2019-9.
Yes, 2019-9. Okay, Sarah. 11, 12, and 13.
Yes.
Para 11, my lord. Secondly, the High Court ought to have seen that when a remedy of appeal under Section 104(1) read with Order 43 Rule 1R of the Code of Civil Procedure 1908 was directly available, Respondent 1 and 2 ought to have taken recourse to the same. It is true that availability of a remedy or appeal may not always be a bar for exercise of supervisory jurisdiction of the High Court. In so and so, this court held that though no hurdle can be put against the exercise of constitutional powers of the High Court, it is a well-recognized principle which gained judicial recognition that the High Court should direct the party to avail himself of such remedies before he resorts to constitutional remedy. But courts should always bear in mind a distinction between cases where such alternative remedies is available before civil courts in terms of the provisions of the Code of Civil Procedure, and cases where such alternative remedy is available under special enactments and or statutory rules. In the fora provided therein happen to be quasi-judicial authorities and tribunals. In respect of cases falling under the first category, which may involve suits and other proceedings before civil courts, the availability of an appellate remedy in terms of the provisions of CPC may have to be construed as a near total bar. Otherwise, there is danger that someone may challenge in a revision under Article 227 even a decree passed in a suit on the same grounds on which Respondent 1 and 2 invoke the jurisdiction of High Court. That is why a three-member bench of this court, while overruling the decision in Surya Devi, pointed out in Radhesham that orders of civil courts stand on different footings from orders of authorities or tribunals or courts other than judicial civil courts. Therefore, wherever the proceedings are under the Code of Civil Procedure and the forum is a civil court, the availability of remedy under the CPC will deter the High Court not merely as a measure of self-imposed restriction, but as a matter of discipline and prudence from exercising its powers of superintendence under the Constitution. Hence, the High Court ought not to have entertained the revision under 227, especially in case where a specific remedy of appeal is provided under the CPC itself. Then, my lord, the latest one is 2022 Garment Craft, my lord. 2022 Volume 4. Garment Craft versus Chandra Chan Goel.
Yes, 2022 4.
22 4 SEC 181. Paragraph 15 and 16.
Para
15 and 16. Having regard to having heard the counsels for the parties, we are clearly of the view that the impinged order is contrary to law and cannot be sustained for several reasons, but primarily for deviation from the limited jurisdiction exercised by the High Court under 227 of the Constitution of India. The High Court exercising supervisory jurisdiction does not act as a court of first appeal to reappreciate, reweigh the evidence or facts upon which the determination on the challenge is based. Supervisory jurisdiction is not to correct every error of fact or even a legal flaw when the final finding is justified or can be supported. The High Court is not to substitute its own decision on facts and conclusion for that of the inferior court or tribunal. The jurisdiction exercised in the nature of correctional jurisdiction to set right grave dereliction of duty or flagrant abuse, violation of fundamental principles of law or justice. The power under Article 227 is exercised sparingly in appropriate cases, like when there is no evidence at all to justify or the finding is so perverse that no reasonable person can possibly come to such a conclusion that the court or tribunal has come to. it is axiomatic that such a discretionary relief must be exercised to ensure there is no miscarriage of justice. Explaining the scope of jurisdiction under this court and so and so. So these are the 1997, my lord, volume 3. I don't think we'll burden my lordship with this.
Yes.
Well, I've already prepared my written submissions also, along with the decisions. So to sum up, my lord, regarding the maintainability, of course, we have gone into a little bit into the merits also. Perhaps the trial court was not aware of regarding all this at that point of time. The trial court was only on the point that you were aware that we had passed an order on 7/3 that you have to deposit the amount, and yet instead of depositing the amount to the to the account of the decree holder, you have deposited. So the trial court took the steps of putting a stop, and rightly so. There is no illegality committed here by the trial court. My lord, from the list of dates, time and again, they were given a chance to file a written statement. They did not. They came before this court on second appeal. There also, this court said, you can go to the trial court, file an application, suitable application, in respect of the disputed bills. That also they didn't do.
It was double billing.
Yes. And now they come before this court and says that we should exercise jurisdiction under 227.
You see, Mr. Digdo,
Yes.
the fact remains that it is a well, what should I say? Is to be reminded that procedures are handmaid of justice. So we'll have to see how procedures, employed by any court for that matter, would serve justice here. So that aspect has to be considered.
Yes. But you'll see the conduct of the petitioner.
That, of course.
Conduct of the petitioner is also not, it's unbecoming. You come before this court at first instance portraying all this. Luckily for us that they have, my lord, annexed a copy of the statement. That's when the matter came up to me, then I thought I should know what the statement is all about. Much obliged.
Yes. So who else? State? Only one respondent? Yeah.
No, here the director of sports also has been made. No. The director of sports also has been made a party. In the case filed by the State Sports Council, who is the same person.
Yes.
This is the first, in fact, my lord, this is the first case where the petitioner has also responded. I have never come across such a case.
Yes, who's appearing for the director of sports?
Yeah, 2 and 3, I am the respondent.
Come. You are 2 and 3.
2 and 3. So far, I have not made any submissions. Because today I was not ready. Otherwise, I would definitely endorse the submissions which have been forwarded by the State Sports Council, as well as the submissions which is forwarded by Mr. K.C. Gautam, who is for the state.
But this court would observe that
My lord, what
you
may I
see, you are, when the whole proceedings is produced, you are part and parcel of the sports council.
My lord.
How can you be made a respondent here? What is the what is what?
My lord, no,
see,
because
what,
this case was filed by the
what is the prayer against
State
you?
Sports Council, my lord. They have filed in their wisdom, my lord. I have been arraigned as a party, my lord, because state is one of the
No,
parties.
but you see, in course of the proceeding, you should have made a prayer for your name to be deleted if not
But
required.
even
you are
if-
not a necessary party.
My lord, however, the state is there, my lord. Number two is a party. 2 and 3, my lord. 2, the state of Meghalaya represented by Commissioner Secretary to the government of Meghalaya. So sport and youth affairs department. So sports department is still a party, my lord. And number 3, of course, is director of sports. But my lord will kindly see this is two different official positions, my lord.
No, exactly.
Maybe the same person, my lord. There could, my lord, there may be an instance.
On that we are clear.
My lord, there may be an instance where, my lord, 2 separate persons may be holding these 2 different posts, my lord. Now, in this instance, same person was holding 2 posts, but the fact remains these are 2 individual posts, my lord, different posts.
But as is evident,
But my lord,
when it comes to to the maintenance of the account or running of the account, it could be joint account or the account of the sports council. You are very much aware.
my lord, the problem is none of these affidavits or whatever has been exchanged, none of them are before me, my lord. I have not gone through them.
Too late in the day to say that, Mr. Chaji.
No, because no copies were supplied to me, my lord.
You are very much in the proceeding since the matter was taken.
My lord,
up.
because submissions were being forwarded by both the councils, my lord.
Exactly.
However, my lord, what I was thinking, my lord, after all the submissions are complete, I could have added a few things here and there, my lord. Of course, today I was not prepared. But however, my lord will kindly see, the address is being made to the chair, not to the person. We cannot say that it is addressed to one person.
No,
The address is being made to the chair, my lord.
We are not talking about
Yes,
an
because-
individual.
no.
We are not talking about an individual here. We are talking about the
Because my
office.
senior has made a submission that same person is appearing. But my lord will kindly see the here Meghalaya State Sport Council, and then comes respondent number 2 comes the Secretary Meghalaya State Sport Council. So my lord, this is a different entity.
That will be
Who
considered.
is being addressed? The chair is being addressed, my lord.
That will be considered.
My lord.
But we
So
are talking.
where can there be a bar, my lord?
We are talking about the functions. We are talking about the actions. We are talking about the intention of the entities as they stand.
Now even assuming, my lord, even
compared to the apparent the personal knowledge that ought to have been there.
no, my lord, even assuming, let us for a moment, even for a moment, if it is assumed that, my lord, one person, he was very much aware of how the things are happening. On purpose, let's assume for an instance, my lord, on purpose he have transferred the money to a certain account. My lord, can he be summoned to the court and directed that you please pay the account? From that account, you make payment. Can that direction be issued, my lord? Even if that is there has to be a certain procedure. Notice would have to go to the sports council. There is a certain procedure for that. It cannot be that at a gunpoint, it cannot be, my lord.
If such a situation has come to pass,
My lord.
What was your reaction then?
My lord, because it's a long pending matter, my lord, it's happened long back. I clearly remember immediately a miscase was filed there. But my lord, thereafter, since matter proceeded here, nothing happened to the case there. If lower court is...
If a miscase is filed there, that means...
Yes, immediately filed, because at that
They
point...
should come up with a clean hand.
Yes, that was filed long back, my lord. Filed prior to approaching this court. That was filed by me. So therefore, my lord, if lower court record, because it's time has gone, my lord, if lower court is, this honorable court is kind enough to, my lord, call for record from the lower court, lot of things will be clear, my lord.
But this matter has been disposed of. Not disposed of.
Yes, it's been disposed of. According to our knowledge, there is no miscellaneous
Then
case.
where-
They have
No,
come,
my
State
lord.
Sports Council has come 4 months after the order.
No. Immediately there was a
4
miscase,
months.
if I am not mistaken, my
This
lord.
application has been filed 4 months after the...
My application is immediate, my lord, if I am not mistaken.
See, Mr. Chaji, now you come with that contention.
My lord.
You have to.
No, it
you
is
have
a
to substantiate that.
It is my lord, unless the record is called for, my lord. Otherwise, I will have to go and check for the records, my lord.
You would have your own brief. You would have your own record. If you have filed such a
My lord, it
application.
was long back. Thereafter,
Long back or not, you see, the file would be with you, which means it would be with your client.
No, my lord, after the matters were over, I had handed over the. I'll have
It
to
would
check,
be
my
with your
lord.
client. You have to get instructions.
I'll have to check, my lord, because
This is
because here I was.
Now, if that's the case, my lord, then this petition also goes. Why have they come under 227? If that contention is correct, that there is a miscase there, why did they
That
file
is why, my
227?
lord, my prayer is, my lord, this honorable court can always call for record, my lord.
Why should the court
For-
call for record?
My lord, because it will be necessary, my lord. It appears it will be necessary in the instant case, my lord.
records have not been called. Kidan MT low court record. No?
Yes, they're there. Local records were called for, I think, since the initial.
Most probably. Most probably. Let's see the order. The order sheet. Yes. Right, order.
Initial, right, I think if I'm not mistaken, one of the only matter was
Maybe.
submitted, only the records were called for.
Right, order. It
What is she?
But you see, Mr. Bhattacharya, whatever the case may be, even if a miscase has been filed, what happened is the mandate of this court is to comply with the direction of the Supreme Court. Now the Supreme Court was seasoned of the proceedings under 227. Or was it 227?
Yes.
Or the second appeal?
227.
So, based on the observation made therein,
That's left that open. Maintainability to be raised before.
so
at this stage, we are just confined to maintainability.
so that maybe that would not be relevant.
Yes.
So, my lord, as far as maintainable is concerned, because I was by and large, relying on the, my lord, submissions being made, forwarded by the state as well as the state sports council, my lord. Because otherwise, we are endorsing their week.
Heard Mr. T. Dengdo, Learned Senior Counsel, appearing for the respondent. Mr. K.P. Bhattacharya, Learned Counsel for the respondent 2 and 3, respectively, has submitted that he may be allowed to advance his argument on the next date fix, since he is not personally prepared for the hearing today. Similarly, the Learned Counsel for the petitioner has submitted that he may be allowed that the petitioner may be allowed to respond, if so instructed, to the argument made by the respondent. On frame it, when do we
Parties
listen?
also at liberty to file their written submission.
Parties are also at liberty to file their written argument. on Primate, list this matter. Let's fix a date. No, it has to be on the week, following 22, 22nd, or we'll have it on 25th.
My lord.
This is matter on 25th.
Obliged. Item number 7.
Yes, Susupiri. Yes, Mr. Numan. Mr. Debra, have you filed any report?
Your Lordship, in these matters, I sought for instruction, and some instruction has come.
Excuse me.
Yes, Mr. Numan.
Lordship, this is the same thing only. This is the same thing which is reflected in the impugn order also. Is this a empty formality in issuing this letter?
They have, they have nothing to improve on their case.
Lordship?
They have nothing to improve on their case.
Nothing. It's the same only, but my contention is that, Your Lordship, after it was remanded back from this honorable court to the department, directing us to submit a representation before the authorities, and the authorities, after due consideration, if I am found eligible, then they should consider. If not, the matter ends there. Now what they have done, Your Lordship, after it was remanded back to the department, I filed my representations. After I filed my representations, the impugn order was issued. Now I'll read the impugn order, Your Lordship. That is at page 90, Your Lordship, annexure 12. What is Page 90, Your Lordship.
If you're launching into your argument, then you start from the beginning, from facts.
Your Lordship. Lordship, the petitioner was enrolled as a recruit rifleman, Your Lordship. That was in the year on 21/5/1986. That is, we'll find, Your Lordship, at page 3 of my writ petition, paragraph 2. He was enrolled in Assam Rifles on 21/5/1986 as a recruit rifleman GD. Thereafter, he was promoted to the rank of Naik, Your Lordship, with effect of from 2/4/1995. The petitioner was thereafter promoted from the rank of Naik to the rank of Havildar GD with effect from 10/10/1997. Then, Your Lordship, he was promoted to the rank of Havildar to the rank of Naib Subedar from 1/9/2007. Since then, Your Lordship, he has been serving in this post, which he was thereafter promoted again in 2022 during the pendency of the petition. Now, paragraph 3, Your Lordship. Now, there is some basis, Your Lordship, as to how promotion has to be promoted from the rank of Naib Subedar to the rank of Subedar, which is covered by the recruitment rules, Your Lordship, of the Assam Rifles, and the basis of which is seniority cum merit and the certain conditions. Now, those conditions, Your Lordship, will find at paragraph 3, that should have 3 years service in the rank of Naib Subedar GD, should be in medical category shape 1, should have passed map reading standard 1. And further, Your Lordship, for further promotion, there is a 9-system grading system, Your Lordship. That is for in the ACR. That, Your Lordship, I'll point out, Your Lordship, at paragraph 4. Paragraph 4, page 4, Your Lordship. Next page.
Yes.
Paragraph page 4. Now, outstanding is 9 points. Above average is 7 points. High average is 5 points. Now, I'll go only with these 3 heads, Your Lordship, because we are concerned with above average and high average. Now, paragraph 5, Your Lordship. That is annexure 1, Your Lordship. A letter was issued by the department also, Your Lordship, laying down the criteria for promotion. I'll read annexure 1, Your Lordship. Annexure 1, page 15. Page 15, 1/5. Annexure 1.
Yes.
This is the letter dated 25 June 2012.
Yes.
Reference ROI, Your Lordship, for so-and-so and feedback received from environment in response to this DTE letter so-and-so dated 20th March 2012. After due deliberation, it has been decided that ACR criteria for promotion of all the CAT from Naib Subedar to Subedar and Subedar to Major Subedar will be as per the revised ACR criteria mentioned at appendix. The ACR criteria mentioned at serial 3, 4 and appendix B to F and serial 4 and 5 of the appendix H of ROI 4 of 2002 may be please be amended accordingly. Now, Your Lordship will go to the next page, page 16. Now we are concerned, Your Lordship, with Naib Subedar to Subedar.
Yes.
This is the ACR criteria for promotion.
Yes.
Annexure 2, dated 25th June 2012.
Yes.
A, Lordship. 3. Out of the last 5 report should not be below above average. That is 7 points, Lordship.
Yes.
And the remaining 2 reports should not be below high average. Out of the last 5 reports, 3 reports must be from BN so-and-so, Lordship, not applicable, so-and-so, Lordship. Now, D should have been recommended for promotion for the last 5 reports. Now, Your Lordship, what has happened in my case is that I had secured 7 points above average on 2 occasions and 5 points of high average on 3 occasions out of the total 5 years, Your Lordship. Now, my case is that just a moment, Lordship. Now, thereafter, Your Lordship, after these criteria were laid down as what to be the procedure, then, Your Lordship, a vacancy arose, which I had the legitimate expectation that I will be promoted. Now, Your Lordship, sometime in the month of July 2018, a DPC was held. After the DPC was held, a junior incumbent who was junior to me was promoted. Then after, Your Lordship, then being aggrieved by that, I came before this Honourable Court, challenging his promotion and the manner in which the ACR which has been issued, Your Lordship. Now, Your Lordship, I'll take Your Lordship to paragraph at page 6, Your Lordship. Page 6, at point number C. Page 6 of the writ petition, Your Lordship.
Yes.
I'll read, Your Lordship. C. That if there was any ACR grading which had resulted in denial of promotion to the petitioner to the next higher grade of Subedar, such ACR grading ought to have been considered as adverse report weak point. However, the respondent, acting in a highly arbitrary and discriminatory manner, relied on the said uncommunicated adverse weak point and denied promotion to the petitioner. The record of instruction number 4 of 1907 of the respondent places a mandatory duty on the initiating officer and the reviewing officer to communicate weak points in ACR to the concerned person. Now it says, Lordship, that is at Annexure 4, which I have quoted in my writ petition. 40, Lordship. Weak points, adverse remark of reporting officer in the CR will be communicated to the GCO
Over this one.
in writing. Remarks of reviewing officer where applicable will be communicated in writing through the initiating officer. Representation and complaint against weak points and adverse remark communicated to a GCO will be submitted within 60 days and after the date of intimation of remarks to the GCO concerned, the representation complaint will be routed through the concerned DGR. Now what has happened in my case, Your Lordship, these weak points were never communicated to me. These weak points were never communicated to me, and the law settled on that point also, where, Your Lordship, uncommunicated ACR should not be taken into consideration at the time of promotion. Your Lordship is well aware about several Supreme Court judgments. However, Your Lordship, after I had approached this Honorable Court gave a liberty to the respondents, Your Lordship, by directing me to file a representation before the authorities. Now I'll read, Your Lordship, the order passed by this Honorable Court that will find, Your Lordship, at Annexure 8. I'll just Annexure 8, page 80.
Yes. Yes.
Then, Your Lordship, page 81. Page 81, Lordship.
Yes.
The respondent authorities are directed to communicate the entries made in the ACR to the petitioner to enable him make a representation, if he so chooses, within a period of 1 month. The representation so presented will be decided within a period of 1 month, thereafter in accordance with law. Further, it is directed that if the entry is upgraded in consideration of the representation, the respondent authorities thereafter shall consider the case of the petitioner for promotion retrospectively by holding a DPC. The entire exercise shall be within a period of 6 months from the date of receipt of the certified copy of this order. Accordingly, the writ petition is allowed to extend as indicated above and dispose of. Thereafter, Your Lordship, I had filed my representation before the authorities. That Lordship will find at Annexure 9, page 82. I filed my representation, Your Lordship,
Yes.
as per the directions of this court. Now, after I've submitted my representation, Your Lordship, what the authorities did was, at page 84. 84.
Yes.
They furnished me a single piece of paper, because if ACR has to be furnished, Your Lordship, it is a bunch of papers whereby entry has to be made by all the inquiry officers as what is the grading. Now they have submitted me this one sheet of paper saying that, I'll read, Your Lordship, at point number 3. As per DPC of 2018, you were not recommended for further promotion due to your ACR not fulfilling the criteria as per headquarters or DGR policy mentioned above. The same are highlighted below for your information. Now can see, His Lordship, in 2013, my grading was 7, 14, 5, 15, 5, 16, 5, and again in 2017, my grading was 7. My shortage here is for 1 year only, which I should have been graded 7 points. Now, while furnishing this, Your Lordship, they never furnish the entire bunch of papers which is required to be furnished as mandatory and as provided in the rules. Then, Your Lordship, I again submitted a representation that Your Lordship will find at page 85, Annexure 11.
Yes.
The relevant portion, Your Lordship, this is a very elaborated representation, Your Lordship. That is at page 87. I have quoted those rules, Rule 40 and 43, that it has to be communicated.
Yes.
That Rule 40 has been violated. When they communicated to me, Your Lordship, they communicated only one sheet of paper, which does not show as to why my gradings were low. Then representation, Your Lordship, at page 87, the relevant portions which I have already read, I have extracted those rules. And I have relied on some Supreme Court judgment, which Your Lordship also is well aware, Devdutt, Abhijit Ghosh, Sukhdev Singh versus Union of India. And one more interesting part, Your Lordship, is that in the year 2012-13, I was a very competent officer, Your Lordship, where I have been granted several awards. I was sent abroad to Haiti, and Your Lordship, that will find place at paragraph 9 of my representation. Paragraph 9, Your Lordship.
Yes.
That, sir, in the year 2012-13, I was given the grading of 7 points above average. But in subsequent years, that is 13-14, 14-15, and 15-16, I've been given 5 points high average, which is totally incorrect. My previous year's performance should have been given proper consideration. Proper consideration is the subsequent years, especially the year 2013-14, considering the fact that I've been conferred with various awards, including a letter of appreciation from the Army Chief on 15/8/1996, letter of appreciation from the Director General of Assam Rifles on 29/8/1996, letter of appreciation from Lieutenant Colonel Amulya Mohan, CO designate, headquarters so and so, Your Lordship, letter of appreciation from Major General N.S. Gill, then Your Lordship, cash award of ₹300 on the occasion of Republic Day in 2004, and the United Nations Medal on 1/6/2004 in recognition of the services rendered as a member of United Nations Police in the United Nations Stabilization Mission in Haiti. These were never taken into consideration. So what happened, Your Lordship, after submission of my representation, whereby I have raised all my points, Your Lordship, as to why my ACR should be graded. Should be reconsidered.
Yes.
Now the authorities, the respondents herein, has passed the impugn order, Your Lordship, that is on 29 Jan 2020. Now, why I've come again before this court, Your Lordship? So they have passed this impugn order, Your Lordship. Here, Your Lordship will find place that my representation was that they have to come to a finding as to why I was downgraded. No findings as such, Your Lordship, as to why I was downgraded from 7 points to 5 points for those 3 years, Lordship. Now, interestingly, Lordship, I'll take Your Lordship to page 92 of the impugn order. Because the above paragraphs, Your Lordship, only talks about ACR. It should be 7 points, 5 points. What should be the length of service? Thereafter, again, they come back to that ACR, what is the points, the grading. Then they talk about the High Court order. Then they talk about that because I've been granted the financial upgradation, so I'm not entitled for promotion. In fact, I have a better case when I've already been granted the financial upgradation. When I'm due for promotion, I should have been graded in a proper manner, Lordship. Now, interestingly, Your Lordship will find at paragraph 6 of the impugn order, page 92.
Yes.
This is their finding.
Yes.
I'll read, Your Lordship. Now, therefore, keeping in view the above facts in mind, the competent authority is of the concerned opinion that the duly constituted promotion committee, after considering the entire service records and last 5 years ACR of JC so-and-so, the petitioner, has rightly not recommended him for promotion, as he has been found ineligible for promotion to the rank of Subedar General Duty due to lacking in ACR criteria. The request of the petitioner for upgradation of his ACR grading and or to ignore the weak points has also been examined. And it has been felt that any alteration, this is very interesting, Your Lordship, and it has been felt that any alteration or upgradation in the gradings earned by the petitioner in his ACR for the years 13-14, 14-15 and 15-16 at this stage, Your Lordship, would set a bad precedence and bad paradigm in the force, as a number of employees who have been superseded for promotion similarly will also plead for upgradation in their ACR gradings, and citing his case and example, which however will reopen a large number of cases and would not be in the interest of the organization. This is their finding, Lordship. There's no finding which says why I was downgraded from 7 points to 5 points. What are the reasons? What are the grounds? What are the circumstances?
Yes.
Nothing. But they've come with this ground saying that if I'm allowed, then many other people will come and they'll rely on my case and it will create a floodgate. The letters, Your Lordship, the language of this clearly indicates that I have a case for promotion, but I've been denied only on the ground that my case will be a floodgate, Your Lordship, for all other people, for all other employees, incumbents. Because the directions of this court, Your Lordship, was for me to file a representation, which I have filed. And they have furnished me the ACR, which is an incomplete ACR. Incomplete, which is single page, where there are no entries made by the inquiry officers. That itself shows the actions are arbitrary and discrimination, Your Lordship. And the entire rules has been flouted. And there's, Your Lordship, normally when you have a weak point in your, or any adverse entry in your ACR, firstly, what the authorities ought to have been done was to set a warning against me. After I've been duly warned, if I still repeat the same, then they communicate me the ACR. Both those two were never done. Though after the directions of this court it was communicated, that also the communication was incomplete. Now, Your Lordship, I have already been considered also for grant of pay, Your Lordship, which I have that upgradation of pay. And the bigger ground, the larger aspect, Your Lordship, is the manner in which it has been disposed of. The language, Your Lordship, will be very clear when Your Lordship reads again that my rejection of my promotion is not of my case, but the apprehensions of the respondents, the apprehension of respondents that this will create a floodgate in the entire force, Your Lordship. Regarding that aspect, Your Lordship, I would like to rely on this Supreme Court judgment, Your Lordship.
That is the only, focal point.
Your Lordship. This is, Your Lordship, 2007, Volume 9. Firstly, I'll read the paragraph 7, Your Lordship, before coming to the conclusion of this Supreme Court judgment. Paragraph 7, Your Lordship. 2007, Volume 9, SEC 625, Coal India and others versus Saroj Kumar Mishra.
Paragraph 7.
Paragraph 7, Your Lordship. Page 629.
Yes.
629.
Yes.
Mr. Ajit Kumar Sinha, learned counsel appearing on behalf of the appellant, took us through the said office memorandum dated so and so, Lordship, and submitted that as in terms thereof, pendency of a vigilance or departmental action would itself be sufficient for not promoting the officer, who would, in the event of their complete exoneration, be promoted as from the date his immediate junior was promoted. The impugned judgment cannot be sustained. The High Court, Mr. Sinha submitted, committed manifest error in invoking the seal cover procedure, which is not applicable to the fact of the present case. If the impugned judgment is upheld, a floodgate of litigation would ensue. Strong reliance on this behalf has been placed by Mr. Sinha on unreported decision of this court in Manoj Kumar Singh versus Coal India Limited, and also on State of MP versus Srikant Chapikar. Now, Your Lordship, I'll take Your Lordship to paragraph 19.
Of this judgment?
Yes, paragraph 19, the finding, Lordship.
Yes.
The floodgate argument does not appeal to us. The same appears to be an argument of desperation. Only because there is a possibility of floodgate litigation, a valuable right of citizen cannot be permitted to be taken away. This court is bound to determine the respective rights of parties. Your Lordship,
yes.
It's very clear that for my rights cannot be infringed or violated just because they apprehend other people.
That is apparent.
It's apparent.
See,
apparent
case,
from their finding in their...
Every case will stand on its own facts and circumstances.
Absolutely. Because I have not discussed about the entire facts of my case. In fact, they have come up with this finding. I have reiterated that, Your Lordship, in my writ petition, also, Your Lordship, in my rejoinder, which I have filed. Paragraph 9, Your Lordship, of my rejoinder. Paragraph 9, Your Lordship. With regards to the statement amendments made in paragraph 11, page 3 of my rejoinder. Paragraph 9. With regard to the statements and amendments made in paragraph 11 of the affidavit in opposition, the deponent denies the same and states that the speaking order dated 29/1/2002 was passed without taking into consideration the directions passed by the Honorable High Court, White Order dated 30/7/2019. Further, by speaking order dated 29/1/2020, the petitioner has been denied promotion to the rank of Subedar General Duty on the ground that the petitioner is lacking ACR criteria. However, while passing the impugned speaking order, the respondent has failed to take into consideration the weak adverse ACR that were never communicated to the petitioner, which is in gross violation and violation of their own ACR policy, principle of natural justice, and the order passed by this court, that is on 30/7/2019. The respondents, while passing the impugned speaking order, have also rejected the case of the petitioner on the ground that the same shall create a bad precedent in future, inasmuch as when the petitioner is legally entitled for promotion, the petitioner ought to have been considered for promotion and not that it shall create a bad precedent. On the contrary, the respondents are not concerned with the merits of the petitioner's case, but are only concerned that this will open a floodgate and create a bad precedent. The malified actions of the respondents are in gross violation of Article 14 of the Constitution of India. Furthermore, the impugned speaking order has been passed by the respondent in a most mechanical and perfunctory manner, inasmuch as there is no whisper or categorical finding as to why there was a delay in communicating the weak adverse ACR of the petitioner as mandated under the Record of Instruction number 4 of 1997. With regard to the statement made in paragraph 12 of the affidavit in opposition, the petitioner denies the same and reiterates the statement in paragraph 13-14 of the petition. It is further stated herein that the respondent has relied on a new ACR, Your Lordship, that is of 27-28 September 2016, which was implemented by the respondent by DGAR by letter dated 23/11/2016 and 29/2016, which in my humble submission, Your Lordship, is not applicable in the case of the petitioner, because we are bound by that, the recruitment rules of number 4 of 1997. So that's my humble submission for now, because there's no finding as to why I was downgraded. There's nothing, Your Lordship. I'll reply, Your Lordship.
Yes.
Your Lordship, Annexure 1, page 15 of the petition.
Yes.
Your Lordship, in this, my learned colleague already has explained paragraph 1, 2, and 3, and paragraph 4.
Yes.
Revised ACR criteria will be effective with from 1st January 2013, that is from the DPC of the year 2013.
Yes.
So, Your Lordship, petitioner knowing this new criteria for ACR has going to be implemented, and it will be on 1st January 2013. Now next you will see the page 16. This is the criteria system is given. What should be the criteria? Already as discussed. So here you will also this
Yes.
The annual confidential report, this 4 of 1997, in my affidavit, this page 41. In my affidavit, you will put on page annexure 7. May I read you, Lordship?
Just page 41.
Page 41.
This is
This Director General Assam will given record of office instruction 4 of 97. Annual confidential report. Yes. So introduction is given. It has been generally been felt that the present ACR from the JCOs does not reflect the potential and demonstrate the performance adequately. A revised ACR form to meet the changes requirement and ensure that performance of JCOs is assessed objectively is given at Appendix A to this RY. The printing of this form will likely to take some time, and then hence it is printed from because of available cycles from may be used. The ACR form is divided into 3 parts: personal data, service record, personal demonstration, and personal qualification and pen picture. 6 marking systems out of 9 points shall be adopted. In this outstanding case, 9 points above average, 7 point high average, 5 point average, 4 point low average, 3 point below average, 1 point. The laid down marking system will be followed to indicate the assessment of each quality and for overall grading. Instruction for filing of the forms are given in the FNP the RY. So this is the given for the form, and form also it is given in this RY. So you will see here this in this RY it is given if it is there, they are reportable 2 type: one is inert confusion and another is adverse report. So here in this ROI you will see this is given this only the adverse reports whatsoever it was required to be communicated. So Mandal Advocate has accepted this ROI 4 is 4 1997 is applicable. So if in this situation if you feel you will see even if it is not adverse report, then it is not required to be communicated. So as per our RY, as per norms in our organization, you will see this only the adverse report. So when there is no adverse report, so it is not required to communicate. This is come in page 44. What is called the adverse report?
yes.
The adverse reports. This
31.
Page 44, internal page 4, and point 331.
Yes.
Adverse reports on a JSU is initiated in the following circumstances: when the JSU service is considered unsatisfactory, when a JSU is removable from an appointment or employment in his rank for reason for professional inefficiency is considered necessary. When it is necessary to record intents and character of Jesus which marks his utility to service doubtful. And 32 is given. Before adverse report is initiated on a JCO, he will be informed in writing this shortcoming and warned. He will be given a period of 60 days to show improvement. The officer initiating the adverse reports will mention in this report the date on which the warning was administered and the step taken by him to help the JCO to improve the performance. The adverse reports will be rendered on the adverse ACR form and will be marked adverse reports on the top of the reading. Adverse report may be initiated at any time. So you will see here in this case, in the petitioner, there is no adverse report.
Yes.
And what is the point he has earned out of this ACRs?
Yes.
So subsequently he was recommended for promotion. So had it been that others candidate was not having the better performance, he could have even promoted. And he, my learned friend has referred another citizens that's regarding this seal cover. So there is no question about the
So
seal
at
cover.
that, you see, at that relevant point of time,
Yes.
there was only one vacancy for promotion.
In this matters we didn't clarify.
Yes, Mr. Nobu, you said
Yes. Only one vacancy, only one person was promoted.
so.
I mean, a junior
so
who
how-
had superseded
no,
me.
So how many?
Yeah, juniors is maybe
how
some
many?
others.
How many officers were considered?
This is matter not clear. We didn't how many.
You said junior was.
My junior has superseded
So,
me. That is my concern,
There must have been. See, there must have been a list of candidates.
Your Lordship.
There may be some.
You are one of them.
Yes.
Your juniors or whoever is are also there. There may be also, your contemporary who were considered. That is not known. Do you know about that?
That I'm not aware.
Because you see, Mr.
I'm only aware is that my immediate junior.
You see, it is not.
Whatever the case may be, now we have to
This-
know.
it
We have
is
to
not-
know who were considered for promotion at that relevant point of time, and whether any comparison was made as far as the entries made in the ECR is concerned. And
This is how many percent?
Thirdly, if the other candidates, including some of your contemporary, were considered, and they have they have scored below expectation, then perhaps the person who was promoted is more meritorious. Those those facts have to be, records have to will show that.
You will see in the particular year how many person was promoted. It is not here in the affidavit.
I think that would be relevant, because firstly you say no adverse entry was made or remarks was made against the petitioner. So would any grading given, a grading of 5 or 6
7
or 4 or whatever, would it be,
How many candidates
would
possible?
it be considered, see the gradings according to grading, would it be considered adverse or positive or outstanding or whatever the case may be? Those 9 points are there. So how is
So
the
you will see in this respect the matter then.
how is the petitioner's grading was
Taken into
There's no
consideration.
adverse entry. Why I was?
how it was determined, no?
How it was determined? I was given. If there's no adverse, it means there's no adverse. It should have been graded
Yes, if there's no adverse, then you should have been graded a higher grade.
higher grade.
So why was not that? All those remarks should have been there in your either in your official in the brief.
And besides
in
the
the file.
point, even in the impugn order, it should have reflected. Why?
In the impugn order.
It's silent. That's why I'm before this court, Your Lordship. My alternative submission is that if I am to be granted permission, if any orders pass from this court, the only observation is that this particular order shall not create a precedent if they are so worried about the precedent. It shall not be a judgment to be applied in rem. It should be a judgment only to be applied persona, Lordship. Only for my case.
That would be that would take into account. But
then let it be bring your Lordship. Then we can bring to the notice of at that point of time, in this when this ACR of the petitioner was going to consider, then how many posts was there, and how many person was.
You have to, Mr. In fact, you have to bring
Lordship, something. I found something.
Proceedings of the DPC.
Page 59, Your Lordship. Sorry, page 59 of the writ petition. Page 59. This is the DPC proceedings for promotion from Naib Subedar GD to Subedar GD. I figure, Your Lordship, at E. E is L. Samanda Singh, not recommended. Hidendra Pathak, recommended. Lal Singh, recommended. Sarvesh Kumar Tyagi, not recommended. R.D. Yadav, not recommended. Sadhu Ram Rai, recommended. Kushal Singh, recommended.
No, so it appears that there are about 1, 2, 3, 4, 5, 6 recommended.
2, 3, yes, 6 total.
Now you say there was only one post vacancy then?
Because my case is that I've been superseded, Your Lordship.
No. If it is your case that you have been superseded, you have not made the person concerned a party in this case?
Yes, already made a party. Because this is only a recommendation, can you see? Recommended.
This is a recommendation.
It's not a final order of promotion. The immediate person who had superseded me, Mr. Hirendra Pathak, I've made him a party.
But who? He's not here.
No, he never appeared, Your Lordship.
Okay. Any ex parte order passed against him?
That, Your Lordship, I'll have to see the records.
If there is no ex parte order passed, then he would still be eligible to appear. Yeah, he's respondent 7. Mr. Devnath?
Yes.
You produced this DPC proceedings.
Okay.
Because this page 59 communication, this is the communication of the proceedings, but the actual proceedings would be different.
Your Lordship, order dated 2/5/2022. Two 5/2022. Heard so and so, learned counsel for the petitioner who has submitted that the affidavit of service has been filed as regard notice issued upon respondent number 7. It has proceeded ex parte.
Because you see, if there is only one post, he has been promoted to that post. Now he is functioning in that post. If he are to be promoted, so he has to be relieved, or they make alternative arrangement.
That is for them to take action, Your Lordship.
That is for them, no doubt. So we'll continue with the hearing. You produce those proceedings. Heard Mr. P. Nogri, Land Counsel for the petitioner. In course of the argument advanced by Mr. R. Devnath, Leonard, CGC, on behalf of these respondent.
1 to 6.
You are appearing for respondent?
1 to 6.
1 to 6. It transpired that the records of the page transpired that the records of the DPC proceedings recommendation of which figured in the communication being numbered A, capital A, oblique 15004 oblique DPC capital oblique 2 2018 oblique 443 dated 21 March 2018. Is required to be produced by this court. Accordingly, Mr. Devnath has submitted that he may be allowed to produce the said records on the next date fix. Next date fix. As prayed for, this is matter. Pray aloud. This is matter. 2 weeks. This is matter after 2 weeks.
Obliged.
So nobody, if you, what you can do is you can prepare a written argument and with your any authority that you would like to rely upon, including the one you have cited.
Item number 9.
Yes, Your Lordship. Lordship, we would like to withdraw this matter, Your Lordship.
Heard Mr. S. Satyam Saikia, Learned Counsel for the petitioner, was submitted that the petitioner is desirous of withdrawing this petition. Accordingly, this petition is hereby dismissed as withdrawn.
Lordship, liberty may be granted, Lordship, to approach this honourable court.
That is up to you. That is up to you. Liberty is always there.
About this, Lordship.
In accordance with law, you can always do anything at any point of
Yes,
time.
Your Lordship.
Not necessary to have to give a a direct, or rather to give a specific order in that regard.
No worry.
Thank you.
Hello.